Okay, sir. Good evening, everyone. I'm Nasreen Farooq, the student coordinator of the Pro Bono Club at Kashmir Law College. We are honored to welcome Dr. Hardik Parikh as a resource person for our today's session of the one-week capacity building program on POSH Act. Dr. Hardik Parikh is currently serving as an assistant professor of law at Gujarat National Law University, Gandhinagar. He is faculty convener of the Legal Services Committee at GNLU. He has been visiting faculty for law in more than 14 different institutions of Ahmedabad. He has also served as an assistant professor of law at Nirma University. We look forward to his insights and contributions to this contemporary topic. It's over to you, sir.
Thank you. Thank you for kind introduction. Thank you, Kalpesh sir. Thank you, Yah sir, for invitation for the session. And I'm very happy that from last few days, the session is happening on the POSH. The topic which is allocated to me is with regard to the cases. So I'm just sharing my screen. Let me know once it is visible to everyone. I hope my screen is visible. Yeah, all right. Okay, okay. All right. So, Kalpesh sir, now it's visible. My screen is visible.
It's visible. It's not in the slideshow mode. Yeah. Not
Just
gone.
one.
Okay.
I am resharing again. There was some glitch. Yeah. All right. Now I think it's visible.
Yes, sir, it's visible.
All right. Okay. Okay. Great. Fine. So, welcome to the session. I have been allocated the task to discuss few important landmark judgments cases discussed in the class from last many days. It started from 12th. I believe that this is not an act, rather than it is a culture. It's a particular moral values which are imbibed in our culture from the times immemorial when we are talking about the working women into the society. But as because of multiple reasons, when this particular law is required to be amended, required to be enacted, and what was the basic purpose that has been covered earlier. But let me begin the discussion by giving one liner to you, and I'm sure that you will agree with that. I say law relating to women is equal to a galaxy in the universe of law. Because the more and more you study, there is a big spectrum. I have heard that, there is a mixture of the law as well as the non-law faculties here. There will be participants who might not be coming from the law background. For us also, we have to understand that there is a big spectrum called the law relating to women, where we are not including only working women, but all the laws which are applicable to the women, whether in form of the law of crime, whether it is relating to employment, whether it is relating to payment of compensation, whether it is relating to material relief and so, including labor laws. So we are touching one planet of that, and that's a POSH Act. So when you compare law relating to women as a galaxy of the universe of law, one planet which is the POSH Act, and why last many days you are understanding each and every section, which is itself a interpretational subject. Whenever we are interpreting multiple subjects, it is always going in a detail. And obviously, the biggest challenge in this particular law is it's very easy to understand. I have the barrack of the law. It's hardly having 20 pages of this barrack. But main task and main challenge is about the implementation. Because generally, whatever law we are talking, it's all about giving certain protective measures to the working women whenever they are working during the workplace, in whatever capacity they are working, whatever wages they are getting, and whatever the employer is available in this particular field. It's very unfortunate that because of many incidents, the working women's confidence into the workplace is getting shaken, and therefore the enforcement mechanism is established after the Vishakha judgment, which is, I think, discussed by almost all the resource person here. Whenever you studied that what happened and why the Supreme Court had to read the international law that which is available for the protection of the women, and how it has been included into the guidelines first, and then in 2011 when the bill was introduced, and later on in 2013 it became the act. So we are coming from the culture where we believe in this particular stanza. You have heard many times that yatra naryastu pujyante ramante tatra devata yatre tanatu pujyante sarva tatra phalakriya, where we always talk where women are honored, divinity blossoms, and where women are dishonored, all actions, maybe not, whatever noble action it may be, it always remain unfruitful. We also say shochanti jamayo yatra vinashatyashu tatkulam na shoshanti yutattreta vardhate dadadi sarvada. That means the family in which women may be in any form is full of sorrow. That family meets with the destruction. And when the family in which they are not having any grief, it's always prosperity. And we understand that workplace is also one kind of family. So this is the country where we have this kind of wonderful concept, wonderful belief. And you might have heard this story also. There are wonderful interpretation, you can say. There are some stories which we are getting from Ramayana and Mahabharata. These are the two examples which we are always taking, that when Ravana was, kidnapping Sita Mata, and then Jatayu's role is coming, that he fought that I will not tolerate that any lady is kidnapped in my presence. And even though he was not powerful equal to Ravan, he fought. And ultimately, it is written that he died in the lap of Sri Ram. And at the same time, this is the picture of Bhishma Pitama. And it is very well said that when in a court of Kauravas, then when Draupadi was brought and her sari was getting snatched and she was tried to molest, at that time, all the elders were sitting in that court, but none of the elder could speak anything. And at the end of the Mahabharata, this is the example that Bhishma Pitama, when he was also able to speak, but he could not speak, he could not raise the voice, and as he came in the deathbed of the arrows. So these are the cultural examples which we are having, which always explain that what is a duty individually given to the people, that when a lady is there in a workplace, what could be the proper way to handle the issues with her, what are the way how to treat her, and many more examples are available. When we talk about the 21st century of the progress, many incidents are observed. I am here with the cases which you will get to know, and many cases are so bad that some of the words which are written in the judgments are not able to be written on the screen, because when we read the contention, when we read the different evidences produced before the court of law, and we get surprised. And sometimes when you are orally, morally, honestly, and very virtue, you are always getting shaken that, oh my God, this kind of words are always spoken to the lady. So that's why there is always struggle of the basic need. And when we talk about the equality and gender, in absence of the gender discrimination at the workplace, it's also coming in form of the equality. By now, we have already heard about the aggrieved woman, so there is nothing to be repeated against that. What is meaning of aggrieved woman? The law is very clear about that. What is meaning of workplace? That is also explained here by virtue of the sections which you have already studied. So this point I am just broadly repeating. And what are the examples of the behavior which are constituting the sexual harassment at the workplace is also discussed in a previous sessions by almost all the resource person, either by the audio visual presentation or by the verbal presentation. So it includes all the variety of the activities, because generally when the harassment comes, it is not only in form of the physical harassment. It may come in case of the verbal harassment, in case come without talking to the lady, without addressing the lady, when some other people are putting her as a subject into discussion by showing something, by doing gestures, by different kind of intimidation, by online stalking, online kind of the favors, or putting any situation where she had to subject herself to the different demands. This all comes in form of the sexual harassment. So that has been discussed so far. Now we are going together with the important cases. I have some of the interesting cases here in front of you. You can always take a note of that. And there are multiple important decisions which are shaping the particular culture or particular system of the nation. First and foremost case is Vishakha. I have not here put it as a case because we all know about that how the working lady government servant in Rajasthan was doing the work, and when she was subject to the cruelty, subject to the molestation, then the Vishakha, the NGO, had to move to the Supreme Court. And therefore, from 1997, the guidelines came in existence that now it shall be the duty of the employer to take care about the safety of the women at the working places by the employer. We'll begin with the cases. The first one is about the Saudi Arabian Airlines versus Mrs. Shahnaz Mudabakkal and another. It's a 1999 judgment. After the Vishaka guidelines, this is the first judgment in the history where there is a significant case which is available. I will discuss few important factual aspects along with the ratio which has been identified. Because of the paucity of the time, I have almost more than 20 judgments to be shared with you. And this is only a tip of iceberg, because when we read the legal jurisprudence of the almost all the high courts and Supreme Court of India, the matters are flooded them. And let me tell you, we are only talking about the reported judgment, and that too the cases which have been brought before the High Court or Supreme Court, either by the women by virtue of the challenging the orders of the lower platform or lower officers, or by virtue of the respondent who have been challenging the punishment which is awarded to them. But please let me tell you that there are multiple cases which are never coming into picture by virtue of the formal report, and for which you and me are trying to understand that in case there is a molestation, there is a sexual harassment, can we make the situation better? I'm sure that by now you would have the confidence that now, after understanding this whole thing, many times you will observe that there is actually the molestation, there is actually some of the harassment, but ultimately, because of the ignorance of law, a lady is not able to understand that whether should I complain for this or not. And sometimes because of the silence behavior, many things are taken for granted, right? And therefore, this is only a disclaimer that whatever cases we are discussing are somewhat landmark judgments, which are giving certain kind of contribution, certain kind of guidelines, and it will always corroborate the discussion which has been taken place earlier, which is talking about the procedure, which is talking about the meaning of workplace, which is talking about the meaning of employee, employer, which is also talking about the trial which is required to be done, and which is also talking about the punishment and actions which can be taken against the perpetrator or any person who has tried to take the advantage of the woman. So this is the case in which there was a Miss Sehnaz which was subject to harassment by her boss, and because she was raising the voice, she was taught a lesson by removal of the services. So in 1985 only, she was removed from the services because she was raising the voice against the harassment. Because of this removal, she approached the Bombay Labour Court, and the ground was that the dismissal was completely unfair, and therefore she is entitled for the protection under the Industrial Dispute Act. This is the time where the particular case of Vishaka was not yet into existence, but the matter was already pending in the court of law, and later on the developments are coming. When the matter was brought to Bombay Labour Court, the reinstatement order was passed that she is not entitled for this kind of dismissal, and she should be put back with the back wages, and all the benefits should be given. Against this judgment of the Labour Court, in 1996, the Saudi Arabian Airlines, which is British here, went to the Bombay High Court. And this was the turning point, because now in this case, judiciary got the opportunity to understand that what is the seriousness of the sexual harassment at the workplace and how the evolution of the jurisprudence can come. Later on, High Court observed that continuous harassment was there by the official superior, Mr. Behrani, and she was protesting the actions by very firmly. Now, this particular observation and this opposition by the lady resulted into, it's called Operation Scuttle, in which what happened that first she was threatened that her husband, who was working in Saudi Arabia, he would be subject to any kind of atrocities, he would be removed from the services. Second, she was forced that she should give apology that how she is going against the orders of the superior. And third, when sexual harassment was continued and the higher authorities were unable to tackle the matter, then when they thought that legally they would be responsible, she got terminated. So this kind of multiple actions taken against the lady who was working. And finally, when the Bombay High Court got the opportunity, it was held that by doing such act, the lady has been victimized for a result of refusing to submit herself to the sexual demands of the superior. And such conduct of Mehrani, who was the senior, would squarely fit into the concept of the sexual harassment as defined by the Supreme Court in the case of Vishaka versus State of Rajasthan. So this is the judgment after Vishaka case, when court observed that this is actually the case of sexual harassment where the guidelines are there. There is no law which is right now available with us, which is clearly defining the things together. So this was the case which was available in respect of that. Second interesting judgment is by Supreme Court in case of the Apparel Export Promotion Council versus A.K. Chopra. Many of you would have heard or would have read about the judgment. This is very interesting. Now here the respondent man was working as a private secretary of the chairman of the Apparel Export Promotion Council. This was the private secretary the man was working. And it was alleged that on 12th of August 1988, he tried to molest one women employee and of the council, and the name has been Miss X. Reason being that various matters, Supreme Court is always taking care about the privacy. I'm sure now it is very clear that whenever the matter is relating to molestation, relating to the offenses against women, the privacy is always going to be mentioned. And I'm sure that all of you are aware about the very popular case of Mr. X versus Hospital Z, which is there in a jurisprudence of the constitutional rights. And therefore, the same case, the name has been withheld by the Supreme Court, who was at the relevant time working as a clerk cum typist. And she was not competent or trained to take dictation. And therefore, respondent also insisted her that, okay, you can go with him to the business center at Taj Palace Hotel and you can take dictation there from the chairman and type out the matter. And under the tremendous pressure, she had to accept this. So she went to take the dictation from the chairman. While she was waiting for the director whose dictation was required to be taken, respondent tried. Now here the harassment is starting. You have studied the various instances hypothetically. These are the actually cases, and when you read the judgment, this all things comes into subject, that how actually step by step the case of the sexual harassment is working out. So it's starting with sitting too near to her, and when she is objecting, it is not stopping the behavior, and she is later taking the dictation from behavior. Next, what is happening? The respondent again telling her that she can type in a business center of the Taj Mahal Hotel, which is situated in the basement, and you can come here. There is no error in typing, which could be founded by the director. Now, he volunteered to show that business center for getting the matter typed, and advantage of the isolated place. Again, tried to sit too close. Then the draft type matter was corrected by director, who asked Miss X to retype it. Again, respondent went to the business center with her and repeated the approach. And Miss X warned him again that when she have to leave the place, if will not stop. Like, so see, the harassment is coming again and again by the respondent who is trying. Now, thought Fall went out of the business center, but he came again. And when she was in a lift, the molestation was reported. She tried to save herself by pressing the emergency button of the lift. Again, the door got open. She went. For a few days, Miss X was unable to meet director because she wanted to lodge a complaint. Finally, she could successfully lodge the complaint against the respondent, and then she submitted a written complaint also. Now, as the complaint came to the officer that this kind of activity has happened, the person respondent was under suspension, and charge sheet was saved to him that he has actually molested. Now, when this charge sheet was served to him, he simply took a denial. You can understand that this is what an example which I was giving in the beginning, that learning and reading the provisions of this act is very easy. You can always mug up, you can always remember that what is meaning of what, and actually is very easy. But when practically some issues are coming where the molestation, harassment, or any kind of activities or any kind of abuse of this position has happened in isolation, it is becoming very difficult to prove in a legal matter. And this is actually one of the biggest challenge in the legal system itself. I'm sure that those who are aware about the criminal and civil proceedings, we talk about the evidences, we talk about the charges, we talk about the principles of natural justice. And therefore, as this was the one of the important matter, he denied that there is no allegation. There's all allegations are imaginary, false. Actually, there is nothing done by him. Now, what happened later on? That inquiry officer was appointed. That should be actions, should be proper procedural conduct should be taken against respondent, and management took the statements. Witness statements were taken, and there was an unwelcome sexually determined behavior on the part of respondent. It also came on the record. Officer also contended that the allegation made was true, and therefore the disciplinary authority imposed the penalty of removing him from the service. Now, when the respondent was removed, the matter went to division bench, and division bench took this cognizance that it was only tried to molest, but there is no actual molestation happened, and therefore the removal is not justified. This is the reported judgment by the division bench, that it is only an attempt, and for the attempt, this kind of molestation cannot be result into termination, and therefore the court came to conclusion that this service is not justified. So High Court division bench dismissed the petition filed by the appellant, and then it was concluded that as it was only attempt, the particular case has not been made out, and the promotion, respondent in the case shall be entitled for promotion and to compensate the time loss, and shall be entitled to benefit except back wages. And also it should be posted in any other office outside Delhi at least for a period of 2 years. So this was the observation by the High Court. When matter went to Supreme Court, it was something drastic change, and we got a wonderful interpretation of this particular case also. The case was further, the matter went to the Supreme Court, and against the growing menace of the sexual harassment of the woman, this judgment was given by the 3 judges bench, and it was kind of the review petition, or it's kind of review when the court got opportunity to restate or read the guidelines of the Vishakha. And in Vishakha case, it's very clearly mentioned the definition for the sexual harassment is including very wide aspect of behavior. It may be whether directly or by implication, which may be physical contact or advances, which may be demand or request, for sexual flavor, which may be remarks, which may be showing any kind of obscene material, and everything is considered to be the sexual harassment. And Supreme Court came out that in the sexual harassment, courts are need to examine the broader possibilities of a case instead of getting swayed away by insignificant and narrow technicalities of expression of the molestation. This was the observation. And these cases should be dealt with the great sensitivity, and otherwise it will have a demoralizing effect of the women. And courts are also required to examine the entire facts before filing the thing. And therefore, the Supreme Court held that the High Court's judgment was bad in a law, and there was a overlooking on the ground realities, because there was simply an attempt, but there is something more than this kind of thing also. And therefore, it was High Court has not interfered with the punishment, and reduction in punishment is also have a demoralizing effect. And therefore, the Supreme Court set aside the judgment of the High Court and upheld the order of the disciplinary committee and departmental authority that the removal was correct. So this is the example which is in apparel council's case also, where the Supreme Court has taken a very important stand that any kind of procedural lacunas. Now the same thing when you see the normal legal environment, when the other cases are going to be discussed, a strict rule of evidence, strict rule of interpretation, presumption, proving of the facts are very important. But in this case, apparel authority, this is the judgment where the attempt is also considered as a valid point for punishment which shall be granted under the law. So that's an important judgment by the Supreme Court. The third point is this one, Saurav Kumar Valik versus Comptroller and Auditor General of India. It's a 2008 judgment. I will be sharing this presentation with you. So in case you are noting down the citations, you can always look into that. Otherwise, we can always discuss some of the important points. Now here, the question is about the workplace. What is actual meaning of the workplace? As I told you, it's a 2008 judgment, and the law came in the 2013. And ultimately, at the time, there was a guideline available. Guidelines of Avishaka case was available. Now, the question is about the whether mess is falling under the definition of workplace. As the citation is available, in case you are willing to read this particular case, the very interesting facts are available, because it's an allegation that the respondent, who was the person who was trying to molest the lady, was not during the premises where actual office was there, but next to office, there was a complex where the residential premises, and it was connected with the mess. So in the name is Glen Mess. So Glen Mess was available, and the room number 21 was given to the lady when she was residing. Now the person who was harassing were chasing the lady, and he tried to enter the room also, and it was contention by him that I have done something, but it is not on a workplace. It was in a mess, or it was in a residential premises. And therefore, the act which is available, or the Vishaka guidelines are not available, or it's not applicable to me. And number two, it is not a grave any offense which can be taken as a serious matter, because I have simply tried to interact with her. And then if I am entering to the room, and if it's kind of invasion of the privacy, actions cannot be taken against me. So this was the argument that Mat cannot be treated as a workplace, because it was meant for a residence and it is not a place of work. Now here the harasser, what following the complainant in a room, and there was exchange of verbal communication. It was also followed by the physical touch. Because of the positive time, other details are available in judgment. I have not put everything on the slide, but there is a list of events which has been narrated by the petitioner here, the lady here, that how the person chased into lobby, how he stood at the door, how he pushed the door, and how he entered the room, and multiple interaction happened. These all details are available. Now, it was also submitted by the petitioner. Now, see, the person who is challenging the application of the law is that expression workplace would connote a place where any person of the public could have access. And that of complainant has also lodged FIR alleging violation of section 451 of the IPC, whereby charges are for trespass in a room. Because lady also filed, she was becoming so frightened because of the behavior, when also the harasser told sorry, and it is mentioned in the judgment, and she was so frightened that she took the cognizance she matter was subject to the police station also. Now this complaint came at the rescue for the respondent. So what he is telling, that this is an absurd situation where in a criminal case, the petitioner is facing charge of house trespass, where in the departmental proceedings, on the same ground, it is treated as a harassment at workplace. Now see, this is the example, or glittering example. that when you are filing the FIR, it is a kind of the attempt that in a mess as well as the residential premises, the trespassing has happened. So when something is considered to be the premises where residential premises available, how it can be considered to be the workplace. At the same time, when this matter was reported to the higher officer, the departmental proceedings also started, and these departmental proceedings were getting challenged. And this incident was in a Glen mess at the different room of the mess. And court held that mess is part and parcel of the academic complex, and it is not a residential place. And definition of the workplace should not have to be narrowed down and construed in its applicability. So this judgment is giving this particular final outcome that is to be interpreted for the achievement of the object sought to be fulfilled, namely to protect working women from sexual harassment. And mess was held to be a workplace, and court opined that employment and work, when connected with the conjunction or, gives a wider scope and has to be liberally construed for achieving the object. So to prevent sexual harassment of the working women, it is important that the definition of the workplace should be widened. And it is not necessary that workplace would be only place where actual office is situated. Any extension or institution or hostel or mess where the employer has control of the management would be treated as workplace. So this judgment is very much important with regard to decision that what would be construed as a workplace, and accordingly, if any harassment has happened in this premises, it can be taken. So that's a important observation of this courts in case of the Saurabh Kumar Valik case versus Comptroller CAG General case. Then next is Dr. Punita Sodhi versus Union of India and others. It's a 2011 judgment of Delhi High Court. What is the judgment is this one. So Dr. Punita Sodhi was working under Dr. Malik at the Safdarganj Hospital in Delhi. Now, Dr. Malik started looking to the opportunities that how he can come closer, and because of this particular activities, the entire work environment was completely hostile for lady, and she claimed that it is completely a ruining of this environment of the work. And she also, and when she was not ready to support her his demands, ultimately the Dr. Malik was contended that he went to the asking that she is treating incorrectly the patient, she is issuing false memos, and even the termination of the lady was also sought. Now, Dr. Punita identified 47 instances that this systematically one by one, the particular incidents have happened that he has harassed, and requested that he should be transferred in as it is creating a hostile environment for her. Now, in return, Dr. Malik turned that the lady has done academic fraud and misrepresentation. So again, a cross complaint was filed against that particular lady. Now, when this matter came, Ministry of Health and Family Welfare and their employer chose not to follow the Vishaka guidelines, and instead having an inquiry committee as required by the guidelines, constituting an inquiry committee of the doctor. So when this matter came, instead of creating the committee, which is a complaint committee IC under the Vishaka guidelines, National Commission had it. Now, when this was gross violation of the right, Dr. Sodhi also approached National Commission for Women, and committee was reconstituted with the person who was junior to Dr. Malik, in which opposite the direction of the Department of Personal Training, which has clarified that committee members should be senior to the accused person. So the junior persons were appointed, and then these actions were taken. Now, during an inquiry by the reconstituting committee, Dr. Sodhi was reprimanded both for doubting the legitimacy of the committee and was even issued a show cause notice as to why should not be punished for false accusation. So when the lady is complaining with the 47 incidents, this actually happened, and that too at the hospital. And finally, it was also accepted. Malik complaints was also admitted by the same committee without asking any questions. So he was a senior to that lady, and his complaint was also admitted. Matter went to Delhi High Court, and Delhi High Court clearly observed that there is a big flaw on the formation of the committee itself, because the guidelines which are there, at least that should be followed. And it was observed that inquiry which was taken against the lady was completely flawed. And Delhi High Court recognized in a subject matter that it is stated that often men view sexual harassment as a harmless social interaction, which overlay sensitive women may find offensive, and therefore it stated that it chose to view actions amounting to sexual harassment from the victim's perspective. And it was held the hospital is also workplace. Now a definition of the workplace including the hospital also, and proper internal committee ICC should also be established as per the Vishaka guidelines, which must be constituted and to deal with the complaint of sexual harassment. So entire complaint and entire activities or a procedure which was taken place earlier was scrapped down, and entire action should be taken against the IC which is properly constituted under the guidance under the particular Vishaka case, as well as the law is mandatory. This judgment is applicable today also in every place. Whenever it is held to be workplace where the women is appointed, it is mandatory that this committee should be constituted. So this is what observation in case of the Sodi case. Now interesting case is in respect of the Megha Kotwal Lele versus Union of India. Now what is the important matter in this case? This is a kind of the review. Now, as this case is in year 2013, very well judicial review is always carrying out by the case. So here the petitioner is a coordinator of the Alochana. Now, Alochana is a center for documentation and research on women, and petition was filed in the Supreme Court, where they highlighting a number of individual cases of sexual harassment, argued that Vishaka guidelines are not being effectively followed. The cases were reported. I told you in the beginning that there are a number of unreported cases, and this petition is in form of the judicial review, like approaching court and taking a cognizance through the court that whether the government as well as the different stakeholders are following the guidelines in effective manner so that the justice can be rendered or not. And here the matter was accepted by the court, and Supreme Court was specifically requested that please consider whether individual state governments has made changes to the procedure and policies as required by the Vishaka guidelines or not. Because Vishaka guidelines, as you know, that in judicial audits, the guidelines are required to be made, and then every workman is required, every employer is required to take care about the thing. So whether the state government has made any affidavit or attempt or not, no answer. And therefore, in this case, Supreme Court got an opportunity. So orders were passed time to time against these notices, and main orders are like this. So directions were given that complaint committees as envisaged in Vishaka case would be deemed to be an inquiry authority under the purpose of the central civil rules. So many of you might have asked the question earlier also that there are central civil services rules, there are the state civil services rules, there are the departmental rules under which any kind of actions by the employees, whether it's a misconduct, it's a service misconduct, or it's a violation of the duties, are tackled. And every rules have inquiry authority. So this judgment is putting the complaint committee under the law of the POSH as an inquiry authority, as a central civil service. And the report of the committee would be deemed to have an inquiry report, and the disciplinary authority would act on the report in accordance with the rules. And directions were given. First direction is given to all chief secretaries of the state. So all the chief secretaries of the states were given a direction that you have to ensure appointment of the nodal agent who can collect the details and give suitable directions. And number two, the labor commissioners were also directed that take a steps to ensure that directions were fully complied with. And that's with the factories, shops, commercial establishment, everywhere. The Vishaka guidelines and the law is properly applicable or not. And that is actually the reason today also, when you are working in any establishment, you are submitting reports, you are submitting annual details, that how many complaints have come to the office, how many complaints have been disposed, whether timeline has been followed or not, what penalty has been given. That is because of the guidelines which has been issued by the court in the case. So this is the wonderful judgment which is followed, and many orders are passed time to time against this particular case. Next is a compilation, or you can say the consolidation of the multiple petitions in form of the Jaya Kodate versus RTM Nagpur University. There are 3 different petitions clubbed together, and Bombay High Court passed in common order. Now, what are the petitions? These all petitions were by the lady professors of the university. And any point of time in every separate petitions, the allegations were taken against the perpetrator that some kind of violence, some kind of harassment has happened. And when the matter was brought before the authority, they were transferred and actions were taken against the transfer. And when the Bombay High Court got opportunity, all petitions were clubbed. And here the observation came in form. The definition of the employee in the act is very, very wide. It is not gender specific and shows that there must exist a contract of employment with the workplace, and terms of condition, therefore, or wages are not very relevant. Also, heads of department or employer who has contract with the management and regulate or exercise supervision over the workplace are covered. So definition of the employee has been covered, and actions can be taken whenever any matter has been brought before the authority by virtue of any complaint that has been held in this case. So multiple petitions clubbed together and then judgment came. Next question is coming in form whether any letter in form of the love letter is considered as a sexual harassment. The answer is available in this case, D.S. Garewal versus Vimmi Joshi and others. Now, what is the case about? There's a matter of the Pithogarh. When army unit was situated, Army Public School, which was known as a General B.C. Joshi School. Yeah. So B.C. Joshi Army Public School was run by the society known as Army Welfare Society. Miss Vimmi Joshi was appointed as a principal of the school. Mr. Hitendra Bahadur was a deputy commander of the 69th Mountain Brigade. And at the relevant time, he was posted at the Pithogarh. Now, when he was stationed at Sonmarg in connection with the providing security cover to pilgrims of Amarnath Yatra, he wrote a love letter to Miss Joshi and used to make advances to her. And she reported the matter to the chairman of the school managing committee. But as a result, she got terminated. She resigned from Mr. Garewal. So, as the officer against whom the complaint was filed was very high ranked, and therefore it was held that this kind of actions cannot be possible, and he was terminated. If you want to see, this is the copy of the letter which was written. You can see this on the screen. Allow me to confess that you have fallen in love with you. What man need is woman, love, trust, and faith. When I took deep into your eyes and I found there is abduction and many more things. As time is very less, I'll share this. You can have a look to that. So this was actually written, and obviously it is observed that whether this kind of actions or this kind of letter would come under the preview. Supreme Court found that management of the school was guilty of violating the guidelines because any kind of letter, verbal, non-verbal communication is not, when women is not comfortable, is to be taken as a harassment. And the school management was ordered that you should come out with the complaint committee, which is under the Vishaka guidelines, ascertain that prima facie case which is made by written letter is made against the officer. And if the committee is finding the case, it would submit the report, and also reaffirm that school management was bound to bear the legal cost incurred by the principal, which council fee of 50,000 rupees. It not had complied with the Vishaka guidelines to begin. And in absence of the law relating to sexual harassment, Vishaka guidelines were only reliable source of action and acted as a deterrent, and entrusted strict compliance was done with the respect of the provisions, and mere idea of being prosecution in grave issues were invited by the public ridicule. So this is the example that in case the letters written is also identified as a actionable matter in case of the POSH. Next is Vijay Jalali versus HMT Limited. It's a 2010 case. Now, what is matter here? Petitioner is dismissed from the service because she was beaten by the male security guard on duty. Now, here petitioner, she was complainant and she was dismissed. Why she was dismissed? Because there was a security guard constantly harassing her by verbal as well as by physical advances also. And she was complaining constantly to the management. Management was not taking any action because security guard was under some of the shelter, some of the protection. And constantly when she was complaining and when he was not accepting, she beat her as a defense. She took a defense. And the constant harassment was there. Inquiry officer complained was guilty for abusing and slapping the security guard, and based on the management dismissed that lady only. So whoever complained, that lady was dismissed. Matter went to Madhya Pradesh High Court. And then the dismissal was suspended and held since the petitioner was sexually harassed in the past and complaints were made, but no action was taken thereon. And on the date of the incident also, the sexual harassment was practiced on the petitioner. Therefore, it cannot be said that the petitioner was unjustified in defending herself against the sexual harassment. You can always give penalty for violence, but actions not taken, number one, that should be taken, and actions, inquiry should be started against the security guard. Number two, for violation of the code of conduct, if you are willing to take action, penalty may be levied, but then dismissal is not appropriate when the lady is concerned. So this is the judgment where the lady who are taking the actions by beating the security guard, matter came to the thing. Then next is a judgment of Delhi High Court in case of the Indu Singh versus Union of India. It's a 2011 judgment. Now, what is the important matter here? It's about relating to the CRPF, Central Reserve Police Force. Many matters are there which are including the highest level of the forces also. CRPF, Army, and Police Academy also. There are number of judgments, and I have taken only few in order to establish that yes, the harassment has been held to be conducted here, and therefore I have not repeated all the judgments together. Now here, what are the contention? That the lady was working as a head constable, and she was informed that her promotion was due. And when the post, Kalpesh sir, if you have the right as a host, can you remove this scribe from this script? Yeah, Kalpesh sir.
Yes. I'm trying.
There are some annotation. You can deny the annotation request. I think someone is trying to write on the screen. There are some green color dots, and it will stop the contention. So you can remove from. I am trying. I am writing on my screen with my pen, but some other participants has also written something.
Yes.
So
I
if you
think
can remove annotation, there would be option by which you can go and you can remove the annotation on screen. I think it will be very clear. No, it will be visible.
Yeah. 1 second.
All right. So her promotion was pending. No, that's a matter. Now there was a person who was a sub-inspector, and then when she was moving in the block, one sub-inspector level officer misbehaved with her and told that you are looking very smart, you are being very warm towards your colleagues. Why you don't think about me? You are a widow, you are entitled for a full life. This is the interpretation of the words which have been spoken, or actually the words which have been spoken. And in that case, when he harassed her, she filed a complaint that there is a harassment, and therefore I want to take action against the person who is a sub-inspector. In return, the sub-inspector also lodged a counter complaint on the same date, in which he very categorically told that she assaulted him with the PT shoes, and therefore she also threatened him that I will see you and I will file a false complaint against you. So this is the case of the two cross complaints. One complaint again under the POSH, another complaint when she used the PT shoes to particularly assault the officer. Both complaint inquiry took place, and charge sheet were issued to the petitioner that why she has indulged into act of misconduct, because under the forces, when you are talking with your senior and when some physical actions are used, it's coming under the misconduct, professional misconduct. So for that she was made. I have cut short the discussion, but then the contention and the facts of the case are very interesting, where she voluntarily came out that yes, this kind of incident has happened, and I have beaten him with the PT shoes. So this confession came against her that she has actually violated the violated the rule, and there was no eyewitness also, because the PT shoes were only with the confession. Because of that, the promotion was stopped originally. When matter came to High Court, then promotion was held to be in effect. Dropping of the charge of assault came because again the court took a cognizance that when there is absence and someone is trying to harass the lady, and when she has done something in respect of the self-defense, that entire promotion cannot be stopped. Yes, you cannot give him the wages, that wage loss can be possible. So High Court came out with the observation that promotion should be given, and at the same time action should be taken against the perpetrator when he has tried to use this word which has come into the proceedings in a written format. So this is the classic case where the harassment has happened and lady has responded. So two cases are very interesting, where in a forces, when these highly disciplined forces are available, when these actions are taken. The next case is about from the Calcutta High Court of the Ayesha Khatun versus State of West Bengal. The case in this case, or the facts in this case is, there's a complaint by female teacher which was working with the school and being harassed by the male teacher of another school in the same locality. We talk about cyber squatting, right? Cyber stalking, and the harassment with the help of the mobile phone. This is the classic example of that how the harassment of the lady with the help of technology can come out as one of the classic example of the punishment. So when lady teacher was working with the school, she was harassed by the male teacher of other school, And this harassment came because during the examination duty, she was interested at another center. So she went at the center, and then the perpetrator managed to get the mobile number. He started calling her. And after that, so many messages came. Later on, the matter went to the extent that the morph videos without cloth of the lady was also shown by that person to the lady. And then lady requested that please delete it, don't share it, otherwise it will destroy my image as a teacher. But then blackmailing started. When she was helpless, she filed a police complaint, and criminal case was still pending when this matter came. Now, later on, she also complained to the director of the school education that, sir, this kind of the harassment I am facing by other school teacher, and please transfer me to other school. I want to go away from this area to the other area. Against this request, the director responded that there is no any kind of provision, our management rule, because there is no possibility of shifting you to other branch, and then this kind of transfer is not possible as per our internal rules. So we cannot help you. So the answer of the harassment matter subject complaint came in this way by virtue of the note, and therefore this writ petition came before the High Court. High Court took a cognizance, and the principal secretary was directed that you take a cognizance of this matter, do a full inquiry, and transfer decision should be taken if the school education officer management rule are not providing for any transfer. The principal secretary can offer inform to the education department for transfer, and within 12 months the disposal should be identified. The main part of the judgment is this one: that workplace cannot be given a restricted meaning so as to restrict the application of the Vishaka guidelines within the short and narrow campus of the school compound. Workplace should be given a broader and wider meaning so that the same guidelines can be applied where the application is needed even beyond the compound of the workplace, for removal of the obstacles like nature which prevent the working woman from attaining her place of work, and also for providing a suitable and cognitive atmosphere to her in place of the work when she can continue her services with honor and dignity. So the definition of the workplace again got widened, and the actions taken by the concerned department was found to be unsatisfactory, and then this matter the court took a cognizance and orders were passed. Then the matter of relating to S.K. Das versus Union of India, after the Vishaka law came, 2014 judgment, this is the case. What are the facts here? This is about the Central Administrative Tribunal. So Central Administrative Tribunal observed that complaint committee is deemed to be inquiry authority for the purpose of Central Civil Service Rules 1965, and it would be necessary for the complaint committee to conduct inquiry in the same manner in which inquiry authority would conduct it as per the rules. So this is the case again in which the complaint committee, again in the previous cases we have seen that what's the main status of the complaint committee, and as per the civil service rule, what is the stand? It is considered to be the inquiry authority, and therefore complaint committee cannot return finding of the guilts against the government servant without adopting the procedure of the civil rule 14 of the civil service rule, because here the alleged harasser should be served with a memorandum of allegation on which charges have been framed, along with the list of witness and list of documents by which the charges are proposed to be proven. I am sure that in previous sessions you have already dealt with the inquiry, how the inquiry should be conducted. So there is a procedure which is including the principles of natural justice. That first you are taking the complaint, you are telling the detailed complaint which is given by the lady who has selected this forum. Then you are issuing the notice, all the documents, that who are witnesses which are selected, everything is required to be supported, given to the harasser, and then he or that person should also be given the opportunity to defend himself by virtue of submitting the written statement, by virtue of giving cross-examination right of witnesses, and later on, finally on the merit, the complaint should be dismissed. So this procedure should be followed. That's the main contention of this case. So alleged harasser should also have full opportunity to inquiry about the rebut the allegation, including the opportunity to cross-examine. So as this is the case in which the rights of the person against whom complaints have been filed is identified. So Central Appellate Tribunal set aside dismissal when it was merely based on the prima facie finding of the guilt. Some of the cases when only based on the complaint and the purpose, broad interpretation is given to the complaint, and without giving opportunity if the suspension has been identified, this has been set aside. So this is the example of this particular case. Next is the Orleano Fernandez versus State of Goa. It's a judgment of the Bombay High Court. The fact is something interesting. Inquiry was against Mr. Aureliano Fernandez by the internal committee constituted by Goa University when it was received many complaints from the female students against the sexual harassment. The internal committee passing the ex parte order against him on account of his absence. So when he was found in a particular complaint that is harassing, he was served the notice. And when he could not remain present, the committee started working in absence of him. So ex parte order were passed, and it was concluded that the actions are amounting to grave misconduct and he should be terminated from the university. Now, finally, when charges leveled against him, his termination was there and he was disqualified for future employment from the universities. This all happened in ex parte. Now, this challenge order was challenged before the High Court in Bombay. There is a Goa bench. The High Court observed that internal committee has granted ample opportunities, but he had failed to appear. And in those circumstances, internal complaint committee cannot be blamed and ex parte orders are absolutely okay. No, therefore, the High Court did not find any merit in the petition and it was accepted to be valid. Because the High Court took a contention, the matter came to Supreme Court by virtue of challenging this matter. And this is the judgment by the Supreme Court. Now, Supreme Court observed that the inquiry was completed in a tearing hurry and there was no given reasonable time or effective participation in the proceedings where even though several dates were missed him by because of the medical grounds and hasty manner in which the inquiry proceedings were conducted were against the principles of natural justice as did not give him a proper opportunity of being heard. And this was the procedural irregularities and the entire order of the High Court was quashed and set aside and matter was sent back to the internal committee for conducting fresh inquiry into the considering the principle of natural justice. So this is the case in which the judgment came by the Supreme Court of India by noting down that there is a serious lapse in the enforcement of the POSH Act where there is a mishandling of this entire procedure and therefore the state as well as non-state actor should fulfill the promise of the POSH Act by properly following the principles which are given by the laws. So that's a case which is talking about the thing. As the time is running very fast, I will move a little bit faster because few more cases are required to be discussed. There is a Sandeep Khurana versus Delhi Transco Limited case. It's a 2006 judgment where the incident is between the two friends. No, the respondent and petitioner who have a good amount of friendship and they have a very good terms where they were exchanging greeting cards also. Some incident happened. Because of that, the lady complainant filed a complaint to the officer. And this was the word. Today on 1st November, 4:50 p.m., Sandeep Khurana misbehaved and scuffled with me, causing bleeding injuries. This man has been making filthy telephone calls to me at my office and home, thereby causing physical and psychological harassment to me. So this report was fine. Now, petitioner made a brief report and it was mentioned that there was a quarrel between them and respondent lady caught him with the collar and she was about to slap him. But before she can slap, the person caught his hand. And because of this intercation, some kind of assault was being observed. Now, further complaint came to higher authorities. Department inquiry started because the complaint as well as the written statement came. There was no order of the complainant of article issued to the petitioner. Only one sentence notice was asking him that come before the department inquiry. Again, there is a case of violation of the procedural norms. That there is no detailed things have been mentioned. Only one page and OSHA is available. Matter was further taken by Delhi Commission of Women. It also entered and the person was removed from the service. And also he was disqualified for future employment from the government. The matter was challenged by the petitioner before the Delhi High Court. And then the court observed that it may be a sexual harassment case, but fulfillment of the procedural norms are mandatory. So you cannot simply file the petition and hear it in absentia in a violation of the norms. All the documents, all the details, notice and justification that what is the purpose of his presence, what documents are going to be relied, everything copies are required to be mentioned. And therefore, whenever the disciplinary actions are taken against any officer, if the disciplinary rules are mentioned into the Central Civil Service Rules or State Civil Service Rule or disciplinary actions under the normal departmental rules, they should be followed as per the letter and spirit. So that's a case in which we all have to keep in mind that this kind of actions, whenever taken, the people who are sitting as an inquiry committee member have to take care that rules under the departmental inquiry rules should are followed. Then there's a case of the Sonibai Nathu Kuwar versus State of Maharashtra. Now, this judgment is relating to headmaster, primary teacher, and watchman of the school, because sexual harassment was there to the lady by all the people, headmaster as well as the primary teacher and watchman. It was complaint given to the superior authority, and then she went on medical leave. Actions was not taken because the reluctance will come because headmaster was involved. Finally, the lady also filed a complaint to police station under section 354 of IPC and section 10(3) of this SC and ST Atrocities Abolition Act. Now, there was a tremendous pressure that you should take this complaint back. Later on, charge sheet was done by the police, complaint was transferred, and it was challenged by the Maharashtra Administrative Tribunal. And then it was status quo given, and an application was dismissed that this lady harassment complaints are not considered to be the valid. Matter went to Division Bench of Bombay High Court. The transfer which was challenged was not having any interference, because it was considered that as per the administrative norms, transfer may be proper. But here the one of the most significant judgment is that when the lower officers of the tribunal passed the judgment, many comments and many words were written which was not proper. So under the POSH Act, whenever judgments are written by the inquiry committee or when the appellate authority, what precaution should be taken, that is guidelines is given by this judgment. So it has been mentioned that judicial officers should not make sweeping remarks of general nature about any class of people. It may be women, lawyer, politicians, businessmen, landlord, tenants, doctors. Pen of the judge should be just like a knife of a surgeon, which probes into the flesh only inasmuch as it is absolutely necessary for the purpose of the act. And therefore, this is the judgment giving the some of the guidance that disparaging remarks which are unwarranted by evidences should be avoided. Judgment should not be made as a conjectures and summarize of the personal knowledge. It should be based on the proper appreciation of evidence. And courts and tribunal must refrain from making any observation and remark regarding the personal character of the individual, particularly of the woman, unless it is absolutely imperative in deciding the case. So this is again a binding, interesting point for the committees whenever this kind of inquiry committees are happening. What kind of report and what kind of final verdict should be written. So for that, this judgment is throwing the light. There is one judgment about the Y.R. Midha versus Union of India. Quickly, I will move a little bit faster. It was a case of female stenographer when complaint of sexual harassment was against the petitioner. Preliminary inquiry was conducted. Prima facie evidence was held. Case of harassment was found out. Now, when this inquiry was happened, retired secretary of the Central Vigilance Commission was appointed. And the entire challenge came in this form only. So when the CVC retired secretary was appointed as an inquiry officer, the entire action was challenged, that how the NGO and the person who is a government officer is appointed in form of the retired secretary, and therefore the requirement of law is not satisfied, and therefore the harasser challenged the entire action on the ground of non-compliance with the appointment of the inquiry officers. Finally, court concluded that there is no contention, because here in the case of the sexual harassment, just because of the inquiry officer committee member is retired civil servant, the inquiry could not be held to be void, and therefore inquiry was held to be proper. So that's a case Y.R. Midha versus Union of India. I will move little bit faster in case of the one more interesting case, Kandla Portas versus K.R. Chauhan. Now this judgment is important for this point, that criminal jurisprudence appreciation of the evidence are not strictly applicable to disciplinary proceedings. That was held by the Gujarat High Court. So strict rule of criminal jurisprudence when departmental inquiries are happening, the strict rule when your other criminal matters are happening, there is no requirement to be followed in the disciplinary proceeding. That's the case. This is again landmark judgment by the Supreme Court in case of the Bijuk Chakrabarti versus Delhi University, where the petitioner was head of Department of the Political Science in Delhi University and also appointed as the honorary director of the Gandhi Bhavan. There was lady Dr. Anamika. She complained to the Vice Chancellor that sexual harassment has been done. Committee appointed. Committee recommendation that you issue the letter of warning to him. Number 1, he should step down as a director. Number 3, and he should be debarred from all the administrative position and supervisory duty for 3 years. And the same was followed. This is the contention and this is the fact. Now, report of the committee was supplied to the petitioner, but copies of annexures to the report and no opportunity was make representation. Again, there is a case of the gross violation of the principles of natural justice. And even though the head level officer was conducted, he was suspended, the reinstitution happened because there was a flaw in the procedure for the complaint, and therefore it was held. The principle of natural violation, natural justice cannot be oversighted, and therefore entire action was held to be unconstitutional. He was reinstituted. Finally, case about the false complaint. If there is a false complaint, then what can be done? There's a case of Shah Jayashree Manilal Pushpaben versus State of Maharashtra, where petitioner was a law student, and the law student was found cheating in the examination. And the supervisor caught her. She was taken to principal's office. She tendered apology. Principal issued the show cause notice that you have done the misconduct as per the unfair means of the university exam. And then the contention board constituted, and board found her guilty. And because of the guilty, actions were taken. And because actions were taken, she moved to the writ by virtue of the writ petition to Bombay High Court. And in that writ petition, along with challenging the actions of the board, she also contended the sexual harassment norms. So first time before the petition in Bombay High Court, she came out with the detailed thing that there was a bad eye of principal on her, and therefore this action has been taken. And then she also contended that there is no malpractice, and this is only the fabricated case. High Court very minutely observed everything and rejected, and then it was a fit case which was falling under the matter that there is a false complaint, because till the date there is no evidence on record when she tried to approach the POSH committee or she tried to approach any other officer. So this is very unfortunate incident when a false complaint is taken by a student of law into the court when there is a false thing on her part. So this is the judgment which can be referred in detail, that what happens in case of the false complaints are filed. There's a case about M. Kavya versus UGC where Madras High Court interpreted. This is a recent case of 2014 where after the Vishakha POSH Act came, the two petitioners were female students of university and complaint was filed. Now, this is a very serious matter. Please pay attention to this in case you are working as a faculty of anti-ragging committee. So what happened that this complaint was about the ragging by the friends. They were senior students, and they both lady also filed a police complaint. You must be knowing about the anti-ragging norms. So the anti-ragging committee complaint was lodged. Now, university authorities, instead of considering the sexual harassment committee, considered the anti-ragging committee, and the entire matter was given to the anti-ragging committee. Anti-ragging committee did wonders. What they did, that it was a quarrel between the two group of students. Instead of taking a sexual harassment of the women, the ragging committee took a cognizance, and then all the students were punished. That their action should be taken against disciplinary action of all the students, because all of them are involved into violation. And because of that, university also took a strong objection that this lady should also be suspended, because she went to the extent of filing police complaint, and later on entire semester was there. Matter went to vice chancellor on the sympathetic ground. Suspension was revoked, but then she was willing to tender the apology. Matter went to Madras High Court, and Madras High Court blasted the institution like anything. Why? Because action under the petitioner are completely contrary to the law. Now, this is the time when the POSH Act is already in existence. How come anti-ragging committee can take cognizance of the sexual harassment matter? So this is the classic case. If you want to read the difference between ragging and sexual harassment, an entire order was set aside. Plus, the university was ordered to conduct the special classes for the lady who were suspended, and education got hampered. This is the classic example where the complaint should be taken very seriously in the academic institution also. Finally, there's a case in Jamia Millia University, Muhammad Azimur Rahman, where definition of the sexual harassment is widened by the Delhi High Court. Now here, the lady is an assistant professor with Jamia Millia University. And that person who was a perpetrator was using the mobile phone as well as the different kind of the words which is available. Now, quickly, I will bring your attention. The lady was given the name Kulfi, and she was sending the message. She was addressed as a name Kulfi, and then this kind of message was, she was looking like angel. Tum bahut pyari ho Kulfi. Sakbir sir ke cabin mein aa sakte ho. This kind of words and interaction was happening. And when this lady took a cognizance, then the word which is used in a very flawed manner is also amounting to sexual harassment. So this judgment is important when you have to interpret what is sexual harassment in case of the things. Finally, judgment of the Pallavi Pandey versus Kendriya Bhandar, 2013 judgment, where internship was there of the student and harassment was done by the salesman. and inquiry committee was not including her. So this is the judgment important in order to tell you that whenever any complaint has been filed, informing and putting a complainant into the confidence is also important. So any complaint cannot go in absence of the complainant. So committee should allow the departmental proceedings. The lady should also be aware that what kind of actions are taken. So complainant should not be completely bypassed when actions are taken by inquiry committee. That's the case. Finally, USA Shears versus Madras Refinery. This is the case of the false complaint. Last case, and we'll conclude the discussion here. So Madras High Court heard a complaint of sexual harassment made by the employee of Madras Refinery as a public sector undertaking. Employee alleged that she was denied study leave with pay, salary and promotion because she rejected advance of the general manager of the department. So there's a complaint that there was a advances expected, and that's what he was rejected. After examining the fact, and court held that employees' allegation regarding the promotion and study leave were baseless, as both decisions approach to have been taken in accordance with the company policy. Further, the complaint committee been properly constituted, but the employee has persistently delayed an inquiry, and therefore allegation of sexual harassment was merely a weapon to bargain for promotion and study leave and contrary to the company policy. So here highlighting condemnation of the misuse of the Supreme Court judgment, court held that the employer who is supposed to keep a vigilant eye on the victim and the delinquent is not expected to allow the woman to use it as a shield. So represented the apex court as a means to seek vengeance. It is true that we are bound by the decision of the apex court, but that does not mean that they can be allowed to interpret the suit of convenience of the woman like a petitioner for a personal gain. So it is observation that Vishaka may be a double-edged weapon if it is not used with a wise manner. So keeping with the other decision of the subject, affirm that the court cannot assume that allegation of the harassment is correct unless it is first referred to the complaints committee. So these are the few of the important judgments which are required to be kept in mind. I have added few more judgments also, like Anita Suresh. This is also classic example of misuse of the provision. Because of the paucity of time, I am not telling you in detail, but I will tell you conclusion that this was the incident where the person who was filing the complaint appeared to be false and filed with some ulterior motive. And after careful consideration, the petitioner would dismiss the cost of 50,000 rupees. So this case, Anita versus Suresh, is a latest judgment of 2019, also can be taken into consideration, where categorically the complaint has been found to be wrong and allegations were found to be wrong also. So what is the role of HR department? That has been mentioned here, that HR department should come out with the policy, should also have effective implementation, proper awareness should be there. And these all judgments as a overview can identify us 3-4 important things. One is that following of the guidelines of the related civil service rules are very important. Number 2, the inquiry should be held in compliance with the rules by following all the principles of natural justice, giving all the opportunity to the perpetrator as well as the person who is having accusation of any kind of incidents. Number 3, the details and proper reporting of events as well as recording of witness statements, everything is very important. And finally, whenever the matters are there, the equal interpretation should be given to the procedural aspect which is available in it. So there are a few more cases also I have written, but I will not read it. It's the B.N. Ray versus Ramjas College case, Ashish Kumar Das versus Union of India. This is the 2014 judgment. Then there is a C. Ravichandran Iyer versus Justice A.M. Bhattacharya, M.K. Sharma versus Sangeeta Gupta, Lakshman Debarma versus State of Tripura. These all judgments are there. I have the text with me I wanted to convey. But as the time is very less, I will share the copies of this judgment with you all. Finally, when we have time, Kalpesh sir, we are running out of time.
Yes, lecture already we
All right.
explained. We should.
Okay, just last one point and I'll conclude the point, because there is an endless discussion. The cases are so interesting that we can spend 6-7 hours to understand the cases only, because all of them are very important. Finally, I want to just convey to all the esteemed audience, what is meaning of fundamental right? We all know, right? So what is fundamental right? How many fundamental rights are there? What is the remedy for violation of the fundamental right? That all we know, right? Fundamental rights are something very extreme, very important we understand. And please look to this paragraph number 3 and paragraph number 14 of the Vishaka judgment. Justice Verma, when Vishaka judgment came, it is uttered, each incident result into violation of the fundamental rights of gender equality and the right of life and liberty. It's a clear violation of the right under Article 14, 15 and 21 of Constitution. The meaning and content of the fundamental rights guaranteed in Constitution in India are of the sufficient amplitude to encompass all the facets of the gender equality, including prevention of the sexual harassment or abuse. So why this point in conclusion? The question which can ask before leaving is, what will be my role to protect the fundamental right of working women? That's the interesting portion. We can take it as an entire outcome of this FDP. Generally, we believe that fundamental right enforcement is a duty of the courts only. But let me tell you, if I am working as a head, if I am working as a member, if I am working as a witness, if I am part and parcel of any proceedings, I will also consciously ask to myself that whether I have any right or any role to protect the fundamental right of any working women. If answer will come in positive way, I think we can definitely get rid of multiple things. The judgments are many judgments. There are so lengthy proceedings, and all the judgments have common identification, common thing. That lady which is working is considered to be the very easy target. The issues are happening, and then ultimately the matters are coming to the court. So big question in order to control the position. And I think Kalpesh sir, you can also put it as a one of the takeaway question in the evaluation also, that all the faculty members who are attending this FDP can ask and can write it very clearly, that if any such incidents will observe by me or it will come to me, what will be my role to protect the fundamental right? And if the answer would be positive, I think definitely we will be able to take many things from these particular things. So that's all from my side. I'm very extremely sorry for extending the time limit, but there are many things which can be conveyed, and in a very small way we can communicate, right? So I think that's all from my side. Any question, query, in case we have a time we can take. Otherwise, we'll be conclude.
We should close. I think they can definitely.
I'll share the details. I'll share this presentation so that the judgments can be taken. There are variety of judgments on the proceedings, on the perpetrator's role, on the protocol. Everything is not possible, but yes, main thing we have identified which can give a wonderful eyesight. And I will again request, in case you are faculty member sitting as an inquiry committee member or as a chairperson, read the provision very carefully, take a proper guidance of any kind of authority, or nowadays I think many certified trainers are there. There are many good officers are also there, court judgments are there. Accordingly, I think we can always try to do best for rendering justice, right? That's sir. Thank you, sir.
Sure. Thank you very much, sir, for your insightful. I can see, like, we can see from the messages, it's very difficult to get insight from the particular things are there. What is harassment, workplace, and then the process part, disciplinary part, and then ICC's
At least
rules.
we
How
can try to give compilation of judgments to the participants, sir. If we can try.
yeah,
This all
already,
judgments
yeah,
we
we
can put
discuss
in
in.
compilation, give it to them, and they can always use it for a proper benefit.
Yes, yes, definitely. That's why we discuss in morning and we floated. So we will we'll maybe, I think,
Yeah.
coming up
Thank
with 30, 40 good cases. Yeah. So then it will be
Yes.
beneficial for people at large all over the India. Yeah. Thank you very much, sir.
Correct.
I request Mr. Yah Ibrahim to give a formal vote of thanks to Dr. Hardik. Over to you.
Thank you.
Okay, sir. Thank you, Dr. Kalpe, sir, and thank you, Dr. Hardik, sir. We are very grateful to you, sir, for today's wonderful and knowledgeable session.
Thank you, sir.
We are also very grateful to our dear participants for their patient listening. And we are optimistic that our participants would have benefited from this session, obviously. And let me remind you that for tomorrow's last session, we have Nitika Opal, who is advocate and POSH trainer, and she will be deliberating on international perspective of on sexual harassment. And one more thing, that our tomorrow's session will begin at 11 a.m. and it will conclude at 12:15 p.m. because tomorrow is Sunday, and that's why we have taken pre-noon session tomorrow. And there will be a concluding session as well. There will be our resource persons will be there who will take that session as well. And regarding that exam, online exam, that will be notified in due course of time. And for that purpose, we will issue time, date. So for this purpose, if you have to take certificate, in order to get a certificate, each participant has to deposit rupees 300 for that purpose. Otherwise, for all other persons, it was free. So with these words, that tomorrow we will again meet at 11 a.m. I once again thank Dr. Kalpesh sir, Dr. Hardik sir, and all our dear participants in today's session.
Sir,
Thank you.
there is small question. I think there is one question. What's the equivalent law for sexually harassed working men? I would like to answer that for women, this POSH Act is applicable. But same, if any harassment is happening about the man, there is a disciplinary action taken by approaching the higher authorities under the professional misconduct or under service misconduct. So if men want to take any action, POSH Act may not be applicable. But yes, the departmental rules in which the colleagues are going to be having any kind of effect or any complaint can be filed about the action can be taken. So it's kind of staff disciplinary actions can be taken. I think one question was there, so I would love to answer. Thank you, sir. That's it from my side. Thank you. Thank you so much.
Thank you, sir. Thank you so much.
Thank you. Thank you very much. Good night.